Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about picketing. Cases that should have gone to the Supreme Court of Canada, but didn't. Consumers' cooperative refineries went to court to seek an injunction against picketing employees from the Unifor Union to prevent them from blocking access to the refinery for all of the workers that were coming in that weren't part of the job action. The court allowed the picketing workers the opportunity to block access to the refinery to deal with disseminating information about the working conditions and the nature of the strike action that was taking place to the additional workers who were coming in during the strike action for up to 10 minutes or until the worker expressed a desire to leave, whichever came first. The union argued in court that this wasn't going to allow them to achieve the purpose of their strike action because it allowed people to pass through by simply saying, I just want to be let on my way without having to be subject to the picketing information or disseminated any information from the picketers at all. It essentially allowed the business to carry on its actions as normal, notwithstanding the fact that there was a strike going on outside. And it infringed on the picketers' rights to freedom of association and freedom of expression. And the Supreme Court of Canada had to answer a very important question here about how strike actions are essentially going to be carried out in circumstances where people are just allowed to freely pass by them without paying them any never mind. And doesn't it really facilitate the desires of managers and the employer to allow additional employees to come in to take over the jobs of the picketing workers while they're outside without having to learn about why they're standing outside and without having to be subject to the grievances of the workers and to make informed decisions so that the influence can be exerted over the managers and over the company to change the working conditions. Unfortunately, the Supreme Court of Canada denied leave, which really prevented the court from having an opportunity to decide how strike action is to be carried out. If courts can grant injunctions that essentially allow temporary workers and managers and anybody else who wants to enter a place of work where there is a strike taking place without having any interference, simply unrolling their window and going, I don't want to talk to you, let me in, and then being allowed in, doesn't that really take the thrust out of the strike action? This was the point that was made by the workers in this case, and unfortunately the Supreme Court of Canada didn't really recognize that by doing what it did, the court diluted the right to strike in a way that might ultimately make strike actions not achievable in Canada anymore, not effective in Canada anymore. And isn't that something that requires consideration by the Supreme Court of Canada? Unfortunately, it's going to take another case, another strike, another situation where unions are dealing with workers who are possibly being mistreated before the Supreme Court of Canada has the opportunity to fully clarify what the right to strike actually means and what limitations the court can put lawfully on the right to strike without violating the charter rights of the individuals who are engaging in the strike action. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazenville Creative for putting together these videos. Please like, subscribe, and share with your friends.